Hey everyone, Logan Hertz here with Hazeltine LLC. I'm super excited. We got a really special guest today who's going to talk to us about patent law. His name is Stephan Kinsella. Stephan is a patent attorney and libertarian writer. He wrote an essay slash book entitled Against Intellectual Property, which I linked to in a couple of my past episodes. And we're going to talk today about patent law, about trademarks, about IP law in general, and I'll give the context for it in a second. But Stefan, great to have you on the show. How you doing?
I'm good. Glad to be here.
Thanks for being with us, Stefan. Really appreciate it. So, in a couple of previous episodes, which I'll link to, we talked about the Nelson Nash Institute, which promotes the infinite banking concept. I also promote the infinite banking concept. I have a lot of positive things to say about the Nelson Nash Institute, but I disagree with them a little bit on the strategy for how best to promote the infinite banking concept. And what they have done recently is they have actually trademarked the phrase, the infinite banking concept.
hmm
And they've started taking legal action against people who use that phrase. And by the way, that phrase was in use for decades in the general public before the Nelson Nash Institute even existed. So it's interesting the approach that they have taken. And Stefan has a lot of interesting experience and intellectual insights on this topic. So I wanted to hand it over to Stefan to talk to us about trademarks. And maybe, Stefan, if you can start with introducing yourself a little bit, your thought, and give our viewers an overview of kind of intellectual property. What is it? Why does it
Sure.
exist?
Sure. So I am a basically retired now at this point, but I was a long time practicing intellectual property attorney. I was an electrical engineer by background in undergrad. And so after I started practicing law, initially I practiced oil and gas law here in Houston, Texas, but then I switched pretty soon after to intellectual property law because I have an engineering degree and doing patents was a good career move for me. So I've been practicing intellectual property law for almost 30 years. And intellectual property is a field of law that covers several types of legal rights. Patents, which cover inventions, which is my main specialty, and copyrights, which covers published books and movies and things like that, original works of authorship or art, basically. And then trademark, and there's others too, trade secrets and trademarks. But trademarks are an intellectual property right that governs the exclusive right to the use of a mark or a slogan, something like that, to identify your company's name or the name of your product, something like that. So they all have different sort of bases and arguments. I'm a libertarian writer as well. I've been a practicing attorney with law firms and with companies for all this time. But I've helped dozens of companies acquire hundreds of patents. So I'm a patent attorney. So I understand the system, but help people acquire it. But right around the time I passed the patent bar in 1994, maybe a little bit before even, when I started moving into that field as a libertarian interested in libertarian theory, which means understanding which laws are good laws and which laws are bad laws, which laws should be abolished and which laws are justified. Basically, the libertarian idea of strong property rights, capitalism, free markets, live and let live. There should be no victimless crime laws. There should be no drug laws. There should be no taxes or very low taxes. The standard free market libertarian perspective. Um, I kept wondering about intellectual property because the arguments for and against it were all over the map. You had people that said intellectual property was important because it helps stimulate innovation and is necessary
I'm
for
sorry.
things.
Let me make an important distinction.
Sure.
You say intellectual property, but I think really you're talking about intellectual property law, and even that word we'd
Yes.
have to describe. Like intellectual property obviously exists, ideas
Correct.
exist, they're here, right? You're talking about intellectual property law, the
That's
whole
correct.
apparatus governing, right?
That's correct. And in my writing, I try to distinguish because people use the term in different ways and it leads to confusion. For example, yeah, if I was want to be precise, I would say intellectual property rights or IPR or intellectual
Yes.
property law.
Yep.
And yeah, most people they identify innovation and things that they call your secret sauce, which is technical know-how or knowledge. They call that IP, and the reason they call it IP, which is actually slightly erroneous, as you picked up on, is because they're so used to identifying the legal regime of protecting IP rights with the underlying knowledge, and that this is part of the problem is if I say we should abolish the patent system, people think that you have a problem with innovation or technology because they identify the technology and the knowledge that's protected by IP, intellectual property rights, with the underlying knowledge. And they don't understand that you can separate those things, and you can be in favor of free enterprise and competition and technology and progress without favoring a legal system that that attempts to protect this. In any case, I started investigating the issue as a libertarian because I was a budding libertarian theorist in addition to being a budding lawyer. And I just thought I'm going to become an expert, like a legal expert in IP law. So I might as well be the one guy who can actually sort out the confusion and figure it out. Like I originally thought I would be the one who would come up with a better argument for patent rights and copyright and trademark. But I kept running into problems, which was that every argument I came across was flawed and that was for IP. And I finally realized why I kept failing to come up with a better argument. And that's because IP rights are unjustified and they're violations of private property rights, and they should all be abolished for different reasons. So I wrote my monograph in around 2001 or something like that on abolishing intellectual property. And I've been writing on it ever since. And I built on that insight to develop other libertarian, I write on things other than intellectual property, but my latest book, which was from last year, has a lot of my libertarian theory, contract law, rights theory, punishment theory, legislation versus the common law, but a lot on intellectual property. So all that's in here. They all integrate with each other. And I came to an understanding that, that everything about all forms of intellectual property law, all of them, are terrible for the economy and for individual rights and for innovation, for freedom of expression. As you have seen with the examples of what I would call extortion or bullying by the Nelson Nash Institute, because they have trademarks. The way I would rank intellectual property law in terms of how damaging and destructive they are to human life and to the economy, the patent system is the worst because it impedes and distorts innovation. It slows down innovation and makes the human race poorer because the way the human race becomes richer over time is not because we're smarter than the Romans. It's because we have accumulated more technological knowledge, which makes us more efficient at how we use resources. And that's why every new innovation and breakthrough, scientific breakthrough, technological breakthrough, keeps making the world richer, which is one reason we're not poor right now, despite government taxes and regulations. We keep outstripping the damage done to us by the government by increasing productivity because of technological insights. And those insights come despite the drag and the obstruction of the patent system. If we did not have a patent system, my firm view is that we would have even more innovation and more human wealth and prosperity. We might have flying cars by now and all that kind of stuff. So it's a drag, but that's the source of human prosperity, is the accumulation of knowledge. So that's why the patent system does the most damage to the human race and should be abolished first and foremost. The next most damaging is the copyright system because it lasts the longest. The patent protection lasts for about 17 years. So eventually patented ideas become public domain knowledge, which could be used. I mean, it's an unfortunate 17-year delay before people can start using it, but at least eventually you can start using it. The copyright system originally was around the same thing at the founding of the country. It was a term of around 14 years, extendable once, so 28 years, and you had to register for it. But ever since in the 20th century, with the Berne Convention and other modern treaties and legal systems, the copyright system has just gone out of control. Number one, it's now automatic. You don't have to apply or register or even put a copyright notice. You just get it automatically by writing something or by making something that's an original work of authorship. And the term is now the life of the author plus 70 years. It used to be 14 or 28 years. Now it's well over a century. So copyright, so it lasts forever, basically. But copyright threatens internet freedom by shutting down websites with piracy links. It restricts freedom of speech, freedom of the press, because literally prevents you from publishing a book if you wanted to. If I wanted to write a sequel to Star Wars or to Harry Potter, I couldn't do it. I would be literally, there would be an injunction from a court telling me I couldn't do it on penalty of going to prison. And that is a restriction of the First Amendment's free speech guarantees. So copyright is the second worst. Trademark is the third worst, in my opinion. Now, trademark, unlike patent and copyright, patent and copyright laws were artificial intrusions on the free market. They did not arise on the common law. There was no such thing as a copyright in our sense, or a patent that was developed by common law courts or the Roman law courts in developing the private law, which we all like, the private law, which is intended to protect your body from torts and crimes, and your property from theft and things like that. Copyright and patent had to be invented by legislatures artificially coming up with these rights. The patent system came about as a reaction to the practice of monarchs granting monopoly privileges to their court cronies, and that resulted in the statute of monopolies in England in 1623, which is where the modern patent system came from. And the copyright system we have now came from the statute of Anne in 1710, which was a response to a government monopoly on the printing press. All these things have nothing to do with freedom or the free market. So you could see that patent and copyright system are intrusions onto private property rights, freedom and free markets, and competition and innovation and learning. Now, the trademark system emerged on the common law, and it emerged with somewhat decent roots, rooted in the idea that it's wrong to commit fraud or to be dishonest or to cheat your customers. Okay. So the original idea of trademark, which I still think is unjustified, by the way, I think the trademark law was not necessary. You could have simply dealt with the problem of consumer confusion or consumer fraud with contract law and with fraud law. We already had contract law and fraud law. So that means, for example, if I sell a hamburger from a fake McDonald's restaurant to a customer, I'm pretending to be McDonald's, authorized McDonald's chain, and I'm not. Or if I'm selling a Louis Vuitton, a Chanel purse, a fake Chanel purse, right? Or if I'm selling a an infinite banking concept service or product, I'm communicating information to my customers about what I'm selling them. Now, if I'm selling you a fake hamburger, not a fake hamburger, but I'm selling you a hamburger that pretends to be authorized by McDonald's, but it's not, then in principle, I'm defrauding or I'm breaching a contract with my customers, because the deal is I'm going to give you an authorized hamburger and you're going to give me $5. Okay. In principle, the customer could sue me for breach of contract or for fraud. That's fine. I think, so over time, so obviously what would happen is if there's a McDonald's hamburger chain and I want to start a competing hamburger chain, in reality, this is not a problem. What do most people do? I start the Wendy's chain or I start the Burger King chain. People want to put their own name on things, but okay, let's say I'm some Russian knockoff and I have a fake McDonald's restaurant in St. Petersburg. Okay. Do the customers really care it's not authorized, or they just want a hamburger? I don't know, but that's up to the courts to decide whether or not there was fraud committed on that customer. And if there's a lawsuit and the hamburger chain has a lot of liability to its customers, guess what that means? Then that means that they're not going to do it in the first place, because when they try to get investors to build this fake McDonald's chain, no one's going to invest in something that's going to go out of business pretty soon. So the point is, the common law, the fraud law, the contract law is sufficient to handle cases of what we call consumer fraud or consumer confusion. And you will notice that in this case, the plaintiff, this is important, plaintiff or the person with the complaint is the customer. So he has a cause of action saying, you ripped me off. So there are several problems with the way trademark law evolved to give this right, a trademark right, to a competitor or to a person using a mark. One problem is, so let's take this Nelson Nash example, and I don't know the details of it. I'm sure it's the same old story I've heard many times before.
Yeah, one important distinction
Go ahead.
is that
Sure.
the infinite banking concept was a phrase that was in use before the Nelson Nash Institute, right? It's like
Yes.
they're taking gravity, the word gravity. Oh, we're going to trademark it, right? you know, so
Well,
that
and
I
so
think that's
so
important. So it's
well,
not
let's
something the Nelson Nash Institute did not come up with the infinite banking system.
so like I said earlier, there are, say, the three main types. There's also trade secret. The three main types of intellectual property are patent, copyright, and trademark. Now, for a patent means you apply to the government to get uh, a monopoly right to practice a given invention, which is like a machine or a process. You have to apply for it, and there are certain requirements you have to fulfill. You have to have a useful invention. It has to be novel, which means new, and it has to be non-obvious in view of the prior art. This is why you can't get a patent on something, even if you thought of it yourself, in your basement. If it turns out someone else was selling this 5 years ago, even if you didn't learn it from them, it's too late. It's in the it's in the public domain. So you can't get a patent on something that's been known to be public for more than a year before you filed for it. Okay. Copyright is obtained by simply producing an original work of authorship and writing it down, fixing it in a tangible medium of expression. So so patents require, or you could call it originality or inventorship. You have to have a novel idea. Copyrights require originality, that is some creative expression. And that's usually easy because unless you're copying from someone else, which would be plagiarism, um, it's look, for patents, it's very common for multiple people to come up with a similar invention at the same time. And the reason is because an invention usually comes about when the background technology has reached the point where it's possible to do that. You know, the Romans couldn't have invented incandescent light bulbs back then, not because they were stupid, but because they didn't have all the technology you need to get to that phase. Edison and his contemporaries in the late 1800s, they had electricity, they had vacuum sealing tubes, they had glass making, a filament idea, they had knowledge about electricity. That, that it's obvious that at a certain point in time, there was going to be a light bulb invented. It's obvious that at a certain point in time, someone would have come up with an airplane. These things almost always come about at the same time which is another reason you shouldn't have a patent system, because no one is really a true inventor. They always are incremental, and they're always doing things that are basically obvious at a certain point in time. The transistor's the same way. Lots of inventions are the same way. The guy that happens to get to the patent office first gets the monopoly, like Edison or the Wright brothers for their airplane. It's just ridiculous, right? Now, for copyright, it is usually extremely unlikely that someone would write the same novel as the first guy. You're never going to have someone independently write Atlas Shrugged or Moby Dick. And so that originality requirement for copyright is almost always present. Doesn't mean the system's justified. I'm just saying that's part of the way it works. Now, for trademark, there's no requirement for you to have come up with the phrase or expression. You just have to, under the way the system, in the way the system worked under the common law, if you just started using a name, a brand name, a product name, a company name in the market, you develop what's called common law rights in that geographic region. Now, with the internet and with international commerce, we have a federal and an international system of registration. You file for it. You don't have to come up with it. You just have to be the first one who applies for that and gets a registration from the trademark office. That's just the way it works. You don't have to. If no one had filed a trademark for infinite banking concept or even the initials, then it's up for grabs. Anyone can get a trademark on it. Now, there are some limitations in the trademark law, which is that the mark needs to be, it cannot be inherently generic or descriptive. So, like, you couldn't get a trademark on pencil because even if you're the first one to apply for it, because it's just a description. And if you give someone a trademark on the word pencil, then you would inhibit competition because other people would have to bend over backwards to find an awkward way to describe the thing that they're selling, which is another pencil. Which is why most people, this is counterintuitive to most people, but the strongest trademarks are those that are what we call whimsical or fanciful. For example, if I came up with the name for myself, well, let's say I was selling infinite banking. If I came up with Pegasus Journeys Down the Road to Profit, something whimsical and crazy that's actually misdescriptive or not descriptive, that's a stronger mark. But then, of course, you wouldn't care because you could still say, hey, I'm teaching a course on infinite banking. I would imagine that getting a trademark on infinite making concept is on the edge of being a little bit too generic or descriptive to survive if there's a lawsuit. But who knows? This part of the problem with IP law, patent law, copyright, and trademark law is that the people that hold these rights, that once you have a certificate from the government, like a copyright registration, a patent certificate, a trademark certificate. Once you have that, there's this presumption of validity, and the burden of proof now shifts. And usually, the companies that hold these things have deep pockets and lawyers, and they can bully people, so people just give up or give in. Which is why these laws have a chilling effect on commerce, innovation, and free speech, even trademarks. Um, so, I personally, my gut feeling is that calling this infinite making concept is so descriptive of what this concept is that you can call it the Nelson Nash method or something. So you add something to it that makes it a narrower claim, right? Anyway, but the point is they have this right and they can use it to bully people. This is a perfect example of why trademark law is unjust. Now, you can criticize the companies that you can say they abuse these rights. They're not really abusing it. This is the system. The whole purpose of the system is to enable and to allow legal bullying, right? If I have a patent, I can send you a cease and desist letter, and it's going to cost literally $2 million to defend yourself, even if you win. And which small inventor in his garage can afford to do that? Which is why what happens is you have, for example, if you remember about 10 years ago, there was something called the smartphone wars, and you had Apple came up with the first, I guess they claimed to be the first smartphone with a touch screen and a, kind of an adaptable interface. And also with rounded corners. That was one of their patents. That was a design patent, not a utility patent. Still, it was a patent on the way the phone looked with rounded corners. And Motorola and Samsung and even Google later and Apple, they were suing each other left and right. Now, these are all very large companies with billions of dollars and multiple $100 million of patent war chests and lawyers and legal staff. So they just sue each other. They keep the lawyers employed for 7 years. Lots of legal and technical experts are used. And finally, at the end of this, what happens? They come to a settlement, and my stack of patents is 3 times as big as your stack of patents. So I'm going to pay you royalties, $500 billion, and you're going to pay me royalties of 1.5 trillion. We'll offset the difference, and we'll come up with a cross licensing deal where we can all go in peace and compete with each other like we were doing before, after all the lawyers have gotten fat and rich. And now we just have to raise our prices a little bit to pass it on to the customers. So now you have two or three monopoly or oligopolist, cartelized, basically, manufacturers of the only few smartphones out there. And they can all compete with impunity because they have a deal with each other. They pass the increased costs on to their customers. The innovation is slowed down in the meantime because they don't have as much competition. And they don't have as much competition because all the little guys who would have competed with them, they can't do this. They can't, if they enter the fray, they will be killed by a massive patent lawsuit from one of the big three guys. So you can see why the patent system leads to oligopolies. And the same thing is true in different ways with the other types of IP, like copyright and trademark. Here you have it. So my point is, you could criticize Apple or Samsung, but they're just following the rules of the legal system. Probably in many cases, especially for a publicly traded company, it would be a violation of your fiduciary duties if you're on the board or if you're on the management of Apple and you have a patent trough that you could use to extort your competitors or slow down competition. If you don't do that, you probably would get fired or maybe even liable. So the system almost forces people to use the patent system and the copyright system and the trademark system in unethical and aggressive ways. Now, there are some exceptions. For example, Tesla, under Elon Musk's sort of iconic leadership, I don't know, 10 years ago, and Twitter, by the way, they both announced a policy. We're going for Tesla, I believe they announced a policy. We've got a lot of patents, but we're not going to sue our competitors because they wanted the electric vehicle market to grow. They understood that they have these patents that could give them a tiny slice, a big slice of a small pie. They would rather have a bigger slice of a huge pie. So they intuitively understood that patents are useless and stop competition. So now you're wondering, then why do they have to spend millions of dollars on patent attorneys like me to acquire these patents that they're not even going to use? Like the whole thing is such a disaster. And Twitter had a policy where and they did this to attract employees. They said, if one of our employees comes up with a new patentable method, we'll file a patent on it. But they made a contract with their employees where they said, but we will not assert these patents offensively against our competitors without the permission of the inventor. So they were trying to shackle their hands, and they're trying to say, listen, we're just acquiring patents for defensive purposes, but we won't be a bully. If you do it that way and the shareholders know, then I don't think that the directors or the management can be accused of failing to fulfill their fiduciary duty. But it's very rare that a company will even try this because they don't understand. All they know is Wall Street and the shareholders. All they think is we're a company. Our goal is to make profit. We have an asset. We have trademark assets. We have patent assets, and we have a copyright asset, and we should use them to our advantage. And so that's what's going to happen. And if you criticize companies for taking advantage of and responding to the incentives set up by an intellectual property system, it's like criticizing, I don't know, immigrants or poor people from taking welfare. I mean, if you set out a pig trough full of free stuff, and the purpose is to get free stuff away, to people will line up for it and they will take it. If they didn't take it, we wouldn't even worry about it. But they will take it. But the problem is not the people that respond to natural incentives. The problem is the legal system itself. So in the case of the Nelson Nash thing, I will say that in some cases, I have people approach me from time to time. So now, like, patent and copyright are different. So let's talk about trademark. Like I said, given the system, you can file a trademark on a common expression like infinite banking concept. And because of that reality, if you were doing this as a business, you would be stupid not to try to grab it if that's part of your main business. Because if you don't do it, then one of your competitors could get it first. So the legal system creates this war of all against all where everyone's trying to grab these rights so that they're not shut down from their business. Even if I was a totally innocent, nice guy and I don't mind competition, I don't want to use my trademark right to bully you, I better grab them first to keep you from grabbing them to stop me. Now, in the case of copyright, you don't have to enforce your copyright. In the case of patents, you don't have to enforce your patent, as the cases of, say Tesla and Twitter show. The problem with trademark is, as I understand it, if you get a trademark and then you don't enforce it, then you're in danger of losing it. So let's say that the Nelson Nash Institute has a trademark on IBC, and then little competitors spring up, and then they don't what's called police it. They don't police it. Then they can lose it for dissuaditude or for just it could become generic again or something like that, or maybe someone else could grab it. So unfortunately, the law gives you an incentive not only to acquire trademarks, but then to police them by sending out cease and desist letters and all that. Now, that said, there is an ethical way to do this, and that ethical way is this. Let's say that you're a competitor of you're one of the people selling the service of based upon the Nelson of the infinite banking concept. And the big guy, I don't know, is it true that the Nelson Nash would be like the big guys on the block, like the main ones that people know of?
The Nelson Nash Institute doesn't actually do infinite banking. They have they have a program where they certify what they call their IBC
Right.
practitioners, right?
Okay, fine.
And there are lots of people who do the infinite banking concept. Some of them are officially authorized with the Nelson Nash Institute. Some of them are not. I'm not sure in terms of how the numbers break out, but
So
yeah,
so what they could do, if they wanted to be ethical and not be bullies, which again, they have no incentive not to be, but they were just decent people. You can't really criticize them for obtaining the trademark. You can't even criticize them for policing it. But policing it doesn't mean you have to be extortionate bully. What you could simply do is you could say, listen, like you could send a letter and to someone, you can say, listen, we have a trademark on this term. You're using it in your service to avoid confusing our consumers because we license this mark to all of our licensed or authorized
Mhm.
sellers or service providers. We would simply, we will hereby, we will be willing to negotiate with you and grant you a license to use the term for $1 a year if you simply put a disclaimer on your site saying not authorized by the Nelson Nash Institute. Now, that would be a very ethical and polite way to, then they could keep their trademark alive because they're getting you to admit that they have a trademark. You're doing it under their permission, and the permission is like $1 a year. It's nothing. So you're not really harming them and you're willing to compete with them. You just want to say, look, here's our authorized dealers. Here's people that are unauthorized. Fine. You could do that. No one does this. No one does this because they don't understand IP law and they don't care about being unethical, apparently.
Yeah, there's a lot to talk about there. So that thank you for providing that
Yeah.
alternative. That was interesting. First of all, one of the things that I always find interesting is that within the Nelson Nash Institute, among the leadership and the membership, there is a very strong libertarian impulse. Whether you like it or not, and obviously there are plenty of people who do infinite banking who are not libertarians, but within the Nelson Nash Institute, there's no question that the leadership and the membership are very strongly libertarian. In fact, one of them officially authorized, he has a mug that says taxation is theft and he displays it prominently on his podcast, things like that, right? At the very least, there's a lot of hypocrisy going on there if you're going to loudly
Well,
announce how libertarian and even anarchist you are in some cases. And then you're going to use the apparatus of the government to go and
yes.
bully your competitors. That's pretty hypocritical, right?
Also, it's because there's widespread confusion about intellectual property. Most, even anarchists, I mean, there's a large number of the more sophisticated or principled or intelligent anarchists, mostly the Austrian anarchists, the Rothbardians, who partly from my work and others, they understand that intellectual property law is totally incompatible with the free market system. But your run of the mill libertarians, they think property rights good, and
Mhm.
therefore intellectual property rights good because they're so stupid that they if they hear a slogan or they hear a propaganda slogan, they think it's true.
Right. It's really intellectual property monopoly. It's really what's
Of
going
course,
on, right?
of course,
That's really what's going on because it's not saying I have the right to own an idea. Well, yeah, you can hold an idea in your head. You have the right
correct.
to that. They're saying, and therefore I have the right to exclusively profit from this
Yeah.
idea, right?
Yes,
I
yes,
can
and that's
the
the
ex-
mistake.
the example I always think of is it's a good thing the early Christians had no concept of intellectual property rights. Otherwise, the
I
Bible would
know.
not have been copied so
Of
freely.
course.
The Bible was copied all over the place freely, everywhere.
Well, and
You don't
by the
you
way,
don't
I
hear
mentioned
about the descendants of St. Paul going after those evil
no. In
monks
fact,
who copied the Bible, tried to get their cut.
I think it's
Back and
actually
this was back when books were like way more expensive and
of
way
course
more valuable than they are today, right?
no. Before the printing press, the scribes were the engines of keeping these words alive by copying them. If there had been copyright law, we might have lost lots of things. We probably have lost lots of things because of copyright. In fact, you remember I was talking about the origin of copyright. The first thing they did was they monopolized for about 100 years with this thing called the Stationers Company, printing guild for 1500, something like that. It lasted about 100 years because you had to, if you're an author, you have to go through, you don't have a Xerox printer at your house. You still got to go to this building with people that can have a printing press cranking out things. And so for about 100 years that lasted. And that sort of put a stopper in the genie coming out of the bottle. But of course, that was doomed to failure. And in the modern internet age, we've seen with self printing, the web, and all this, it's gone now. They can't control anything, which is glorious. But at the end of that 100-year period or so, the 100-year charter for the stationers company was about to expire. So then the question is, what do we do now? And under Queen Anne or her successor, I can't remember, 1709, 1710, the Statute of Anne was passed. And what it did was it said, instead of renewing the charter of the stationers company, it created the modern copyright system where it said authors are the owners of copyright, not the publishers. So it looked like it was pro author, but it really wasn't because still the authors had to go to the printing companies to print their books. And that legacy model has lasted until about 20 years ago, which is why artists like Prince had Slave on his cheek, all these musical artists, all these movie stars, authors. They're all locked into these horrible contracts because the publishing industry had the bargaining power because they were the only ones who could print or distribute movies or music in the old days under the physical medium system. They could extort contracts from the artists where they're locked in and they don't even have a right to their stuff. Yeah. So the modern attempt to control thought under the printing press, which you're right, was a way to like let the Bible spread. That it led to the modern system, which lasted, I don't know, from 1700 to let's say the year 2000, basically. Now everyone can do whatever they want. We have podcasts, we have the internet, although that's severely restricted by copyright. Anyway, I'm on a tangent now, but the point is, all this is of a piece. Trademark, patent, copyright, they're all completely unethical. They're intrusions into the free market and freedom, which I know that sounds radical to people that are used to, because you're going to hear the standard thing. Well, if I don't have a right to my name, what's to stop me? What's to stop Burger King from like, well, there's fraud law and there's contract law.
Right, right. And why would they? But also, yeah, you're right. It's called contract law. It's very simple. And
And not only that, as I was hinting at earlier, as I mentioned earlier, you could see a justification for a cause of action by a group of customers or a customer for contract breach or for fraud if they are deceived by a knockoff restaurant or seller of goods or something like that. But the cause of action would be with them. But the trademark law gives the cause of action to the trademark holder. So, for example, Chanel has a trademark on the Chanel name, and there's some company selling knockoff Chanel purses. Then it's not the customers who are deceived that have a lawsuit. It's Chanel. Chanel's not harmed. Their property rights haven't been violated.
Exactly.
And not only that, I didn't get to this point. Here's the other problem. If you had an actual lawsuit by a customer, it would be because of fraud or a contract breach. Contract breach is clearly understood as the terms of the contract. Fraud is understood as you have to deceive someone into basically handing over payment under false pretenses. So those are fairly clearly courts or legal claims. Under the trademark law, there is no requirement. First of all, the problem is, again, it gives the right to the competitor, not to the aggrieved, the defrauded
customer. The customer, the one that it's supposedly protecting, who's
but it
actually
doesn't even,
would be aggrieved, doesn't even get.
They don't
doesn't
have
get
the right
protected.
And moreover, they don't. So it's called not fraud, but it's called infringement. So you committed trademark infringement, which means you're infringing the rights of Chanel, the corporation, or you're infringing the rights of Nelson Nash Institute, even though you didn't commit fraud against them, and even though you didn't commit fraud against anyone, because the trademark law does not require you to show fraud. What it requires you to show is the likelihood of consumer confusion. So, number one, it doesn't require you to show consumer confusion, which is not fraud, by the way. If I confuse someone, it's not clear that I violated their
I
rights.
guess we'll have to shut down the entire mainstream media. They're causing consumer confusion, right?
Exactly. That's my point.
Hey,
You
maybe
have
I
the
like trademark law now. All of a sudden,
that's a whole nother topic.
Oh,
But so the
dude.
point is, you don't have to show consumer confusion. You only have to show, you don't have to show consumer fraud. You only have to show consumer confusion. And you don't even have to show consumer confusion. You have to show the likelihood of it. So that is why you can have a court order from the ITC or from a court that has these steamrollers go and they take fake Chanel purses from some black market in New York or somewhere, and they take and they steamroll, they burn, they destroy these purses, even though the people buying these purses are not confused or defrauded at all. If you buy a $10 Chanel purse, no one in the world thinks that's the real Chanel purse. They know that it's a fake, and they're happy with that. They want the cheap purse. So they're not being defrauded at all. So you can see how trademark law has lost any possible connection it could have to protecting consumer rights under a fraud or even a consumer confusion standard. So that's the background. That's how I would encourage your listeners to think about this, is to see how insidious and how harmful and how dangerous, how damaging it is to have these IP laws, all based upon the confusion that you can have The ultimate mistake people make, they believe you could have a property right in the value of something. This is the fundamental mistake. Property rights, the entire purpose of property rights is to recognize that we live in a world of scarce resources where there can be conflict among people, and there's only so much of these scarce things to go around. That's not true of ideas, by the way. This is why we're richer, which I mentioned earlier. A million people can use a new recipe for baking a salmon at the same time. A million people can use a new transistor idea or a new manufacturing idea at the same time. This is why we get richer, because the ideas spread and we use them to enhance the efficiency and the richness
Right. To
of our
to say
activities.
that a little better, I think in a colloquial way, if I steal your bike, you no longer have the bike. You can't use it. You're deprived of the use of that bike.
It's a
If
scarce
I
resource.
if I steal your idea, you still have your idea. And the only way to enforce the intellectual property is to create a monopoly where now I'm the only one who's allowed to profit from that new salmon recipe. I came up with this new recipe and now no one's
Correct.
allowed to use it. Even despite the fact that if I use that new salmon recipe myself, you haven't lost anything. I've taken nothing from it.
Now this gets in. So this is a little bit technical. This is the way I've been trying to find ways to explain this to people for 30 years. And I keep coming up with different ways of, because these things these are arcane laws, which only specialists like me usually understand. Even the economists and these so-called free market liberals who support them, they don't even understand what they're talking about. You'll hear people all the time conflate patent, copyright, trademark, plagiarism, piracy, fraud, knocking off. These are all completely different and distinct concepts, and they just throw them all together in this mishmash. And if you support piracy, then by the way, the word piracy is also another propaganda term. Piracy means taking people's stuff and killing them from their ship or something,
Right, right.
which is taking their tangible material property that they can't use anymore, like the biking example. But now we use it to refer to using other information you've heard on the market and making a profit off of it. Oh, now making a profit is such a horrible thing. The whole
Or
thing is so
in many cases, not even making a profit off of it, just making it freely available. But I used to work as a strategy consultant, and we used to deal with this stuff all the time. This stuff is so easily addressed, and we would just do non-disclosure agreements, right? So we're meeting with Fortune 500 companies, executives, and so on, and they're giving us very sensitive financial information that obviously they don't want their competitors to get.
right.
So we're dealing with intellectual property all the time. And so we just have standing non-disclosure agreements with all of our clients. And again, the way of enforcing it is not through the government, not through the courts, which is a very inefficient way of addressing it. What happens is we had a case with a guy who he actually um, took a slide from one of the presentations that had gone to a client, and there was no client specific information on it. That's the other thing too, is that they want us to reuse our insights, right? They want that. So they don't want to restrict that because then we as consultants would lose all of our value if we can't draw from the experiences we've had, the best
Exactly.
practices we've learned from other companies. What we can't give them is, oh, your competitor, this is his sensitive financial information, right? And so this particular guy who worked for a consulting firm, he didn't even do anything wrong, it's just an oversight. He was creating some public a thought leadership kind of piece, and he put a slide in there that had 100% public information. There was nothing in it that was proprietary, nothing in it that was sensitive. But he that same and company saw it, called him out for it. And the consequences were very huge for the company. And then that consulting firm was locked out of that company for 2 years. There was a
Right.
massive negative financial impact to them, and no courts were involved. There was
No,
no trademark, no
no, but
copyright, no nothing, right?
yeah, because of course reputation matters more than anything. Number one, but even there, there could have been there could have been a there could have been a lawsuit about breach of contract. There are implicit and explicit agreements people make with each other. If I'm your attorney, there's attorney-client privilege, but there's also an understanding, whether explicit or implicit, that I'm not going to reveal your secrets. And if I do, I'm basically breaching the contract and I owe you some kind of damages. Although the damages from reputation loss are really the main thing that you worry about anyway. But the problem is people, because of this mistake I mentioned earlier, where people equate knowledge and secrets and information, they equate that with the IP laws. So they just can't conceive of the fact that they're separate things, and there are ways to protect one without the other. There's reputational effects. And if you approach a company, if you're representing someone as a counselor or as a trusted advisor, an accountant or a priest, even a husband and wife, depends on the situation, there's an understanding that you are not free to reveal confidential information. And people think that means they think that means that there's some justification for conceiving of information an ownable property right object. And that's simply just wrong. Um, Information cannot be owned. Only scarce resources can be owned. And so what I was going to say earlier, the sort of the actually correct way to understand intellectual property. This applies more to patent and copyright. It's a little bit, um, like I said, every IP right is different in its justifications and its nature. Um, Trademark is more the system of giving someone a legal right to control the free speech of other people. It's something like that, which is a violation of property rights. Patent and copyright are a little bit more clear about what their nature is. I think they're what's called in the law a negative easement, or in the civil law a negative servitude. And this sounds like a legal complication, but your listeners can understand this. Everyone's familiar with the concept of a homeowners association. A homeowners association is where you have a group of people who live in proximity with each other usually, and there is a master agreement among all the people, usually done by a developer when they buy the thing, but it could just be you could just have two neighbors who have they're neighbors and they both have an agreement with each other to restrict how they can use their property. They both say, listen, let's live at peace. I can use my property. You can use your property, but let's both agree we're not going to build a pig farm here. Or let's agree we're not going to build our building more than 3 stories. And that's what homeowners associations usually do. So what you have is you have a contractual or a voluntary agreement among neighbors, and they agree to transfer to each other some limited control rights, and they're usually always negative. So my neighbor can't come into my house and use it. Just by the way, if you own Google stock, you can't go into the Google headquarters and have your birthday party there. There are certain limitations on rights. You can give up a limitation. You can give up some rights of your property. You could say, okay, I give up the right to have a pig farm on my property in exchange for you giving up a similar right. That's perfectly legitimate. That's called a negative easement or a negative servitude. It's also called a restrictive covenant. And this is the basis of homeowners association. Now, you'll see what's key about this is it's voluntary, which means it's agreed to. So there's nothing wrong with me dividing up my property, for example, if I have a driveway that's next to my neighbor's property, and he would rather use my driveway to get to his garage instead of building a separate driveway right next to mine, which is a waste of space. He might just pay me an annual fee for the right to use my driveway. That's another type of easement or a right of use. All this is perfectly fine. You can divide up rights as long as it's done voluntarily by contract. Now, so for example, if I have a printing press, if I have a building, I own the building, I own the land, I own the printing press, I own the ink, I own the paper, and I print books in my building. Okay. I've got a little Gutenberg printing press or a little factory on Amazon, whatever. I'm not violating anyone's rights if I print a book. Is a copy of another book because I'm not trespassing against their property rights. If I print 100 copies of the Bible, I print 100 copies of Moby Dick, if I print 100 copies of Romeo and Juliet, or if I print 100 copies of Harry Potter, I'm not trespassing against anyone's property right. I'm not violating a contract because I don't have a contract. However, if I make a contract with someone, and let's say I'm going to make it a deal with the other publishing house down the street that I will not publish copies of your imprint books and you won't publish copies of mine. That's again perfectly legitimate. That would not be copyright, wouldn't be intellectual property, but it would be a private contract which could be enforced. The problem is when the government grants patent rights and copyrights and even trademark rights to a degree, It's
And I
great.
just have to point out we're totally abusing the word rights when we're talking about these. That's the other thing I don't like about this. Is it
Yeah,
misuses what is a good word that has positive ethical connotations, a right, protecting human rights. And they're taking that word and abusing it. And basically now what they're calling a right is a monopoly privilege.
totally right. The legal,
It's the
the,
right of the tyrants to tyrannize his people.
it's
That's
a legal,
basically what
yeah,
it is.
it's
Yeah.
a legal, it's a legally granted monopoly privilege, but it's classified as a right because under the law you can enforce it. So here you have the bifurcation or the distinction between what we call natural rights or moral rights and positive rights, which the government just grants, and there's no reason for them to expect them to be consistent with justice or property or natural property. But the way to consider this is when the government grants me a copyright, let's say, when they grant J.K. Rowling copyright in Harry Potter, she can go to a court and she can use that right to stop me in my private printing press from printing certain patterns of information on these paper. Now, as I said earlier, that would be legitimate if I agreed to it, but I didn't agree to it. It's the government taking part of my property right and giving it to J.K. Rowling. That's a transfer of property right. It's a stealing. It's a taking of property rights. It's what I would call a non-consensual negative servitude. No, there's nothing wrong with or negative easements. To use the common law language. There's nothing wrong with negative easements if you agree to it. So the whole point is whether you consent or you don't consent. In the case of an agreement in a homeowner association or a normal negative easement, you have consented to this restriction on your property rights, or more properly, to give part of it to someone else. It's totally legitimate. But the government simply takes it from you in the form of so this is ultimately the problem with patent, copyright, and even trademark, is that it's the government granting a negative easement to someone that they didn't bargain for. They didn't get by permission of the owner of what we call the burdened estate. So now you have a burdened estate. The burdened estate means there's a piece of property that I own, and before this happened, I had the right to do whatever I wanted with it. But now there's a limitation. There's a negative restriction of what I can do. I've got to get the permission of the other guy. So if you wanted to sell this infinite banking concept course, now previously you had the before IP law, you had the perfect right to do it because you're not defrauding anyone. You're just selling a service. You're competing with other people. With the trademark system, you give your competitor, you give the owner of the so-called IP right, the right to use physical force to prevent you from using your property as you see fit, even though you never agreed to this negative easement. That's ultimately the
Right.
problem with IP law.
So what you're pointing out in layman's terms is the only way to enforce intellectual property so-called rights is to destroy real property rights because I can't
Yes.
control the ideas that you have in your head. I can
Yes.
only control what you do with the actual property that you own, right?
Yes.
So
This
so
this is this is a really subtle point that's hard for people. Once you understand it, it's easy to see, but it's hard for people to grasp. Because the concept of property rights has been so muddied over the years, because we equate it with property right and value instead of the physical integrity of the thing. But the thing is, once you understand that there are two components of successful human action. Gets back to off-trade economics and Mises. It's just a very simple, this is praxeology, but you don't have to really understand all of this. But the point is, it's common sense to understand that every human action has two essential components. That is to achieve what you want to achieve in life, to do something successful, to have a profit, as we call it, a psychic profit or a monetary profit. To go from here to achieve what you want to achieve, you need two things. You need availability of scarce resources. You have to have things to work with. And you need knowledge in your head that guides what you do. These two things are both essential to successful action, but only one of them is the subject of conflict, is the clashing over these resources. Like you said earlier, everyone can use an idea at the same time. So the property rights necessarily are control rights to scarce resources. That's what they are. Because every law is always the use of force against someone who's misusing someone else's resource when there's a possibility of conflict or clash.
I would say that's civil law Because law, yeah, that's a whole nother. I subscribe to more the Thomistic definition of law, so I would reject your definition of law there. But I think I know what you're saying as in a practical sense, right?
And that's a whole nother conversation. There's in legal theory and in moral theory, there is a distinction between Thomistic natural law, which I'm sometimes calling here moral law or libertarian law, which really just means justified law. I know that there's the natural law
Well,
thinkers.
also like the law of gravity, that's a law.
Yeah, and I'm going to talk on like different types of law. So there's the laws of cause and effect, causal laws. There's also laws of economics. There's logical laws, and these are all about regularities that we can notice in life. And then there's also moral laws, and there's what you can call legal laws. And then the legal laws have two types. One is justified law or moral law, which is a normative component. And then you have positive law, which is the law that actually exists, that the sovereign or the legal system is actually literally enforcing. But because we've come to an age dominated by legal positivism, in a sense, ushered in primarily by the rise of the bureaucratic state, the administrative state in the 20th century, which coincided with World War I and the collapse of monarchies and the old regime and the rise of democracy, which is what Hoppe calls democratic lawmaking. We've replaced the old concept of law as a fixed thing that has to be rooted in morals and norms and natural law to some degree, which is the distinction we make between what we call malum in se and malum prohibitum laws. Malum in se is laws engraved on your heart because of God or moral law or common sense or tradition. And malum prohibitum are things that are just illegal because the government says so. And the common law and the Roman law were more natural law reasoning systems based upon practicalities. And we discovered what the law was. Whereas now, with the rise of the administrative state and democracy for about 100+ years now, everyone thinks of law as, you hear these, even libertarians, they'll say, oh, the income tax isn't legal. It's not illegal to evade income tax because show me the law. When they say show me the law, they're thinking like a legal positives because they want you to show you a book written by the legislature of a government, which is a criminal agency anyway, to prove what the law is. They've lost the connection between morality and the law. So I agree with you. And there was a classic debate 50 years ago between H.L.A. Hart, a sort of a legal positivist, and Lon Fuller about even using these words you're using. Like some people, like you maybe, are reluctant to call a bad law a law because you think you're blessing it with this cloak of credibility because you're thinking like the old world. You think about things like you're thinking that people used to.
I would call it a rule, an edict. There are various words you could use to
I'm
describe
okay
it,
with how you want to
but
describe it. Look, I get in trouble with some of my libertarian friends who are mainstreamers when I say something like, um, the Supreme
because
Court.
even like you mentioned, economic laws are more like tendencies. They're realities,
Well,
but
there are a priori laws too. There are logical
yeah,
laws. There are philosophical laws.
based on human behavior, things like that.
Depends on your take on economics. But if you accept the epistemological approach of the Austrians or some of the Austrians, there are a priori truths we can know, and there are a priori truths. Or yeah, when I say a priori, I just mean there are things that we know that, let's put it simply, they're hard to deny. It's hard to deny that we exist. It's hard to deny that there's such a thing as consciousness, right? It's hard to deny the law of non-contradiction. It's hard to deny the law of supply and demand. It's just, I would say it's impossible, but we don't need to prove these things with an empirical experiment. We don't need to prove that if you raise the minimum wage, you're going to cause unemployment. We know this by logical reasons. So that's a whole different issue. But the point is there are different categories or types of law. And I would say that one of the main distinctions is the one that Mises makes, which is the distinction between the normative or the teleological realm, and then on the one hand, and the causal realm on the other, the descriptive versus the prescriptive. And when we talk about law, it's an interesting intermixture. And again, the people that think that law ought to be moral and based on certain values and certain justifiable principles, they're reluctant to call like the income tax law or certain legislative decrees like IP rights They're reluctant to call it law because they're afraid that they're going to give it some legitimacy or blessing. I understand that. I think we've lost that game because if you want to communicate with people, I don't like the term intellectual property. I don't like to use it. But if I'm going to criticize a set of laws that think should be abolished, I've got to use language people can understand. So it can get tedious to every time say, I'm against IP rights,
Yep.
asterisk.
Yep.
They're
It's
not
kind of
really
like Mike Maloney making the distinction between currency and money. And every time someone says money, he
exactly.
corrects them as currency. It's not money, And
I do the same
uh,
thing with the word state. Like I'll point out that like libertarians, I'm an anarchist libertarian. I'm not against government or law or order. But the thing is take roads, for example. Most people are so used to the way things are, or even social government provided healthcare in other countries. They're so used to the fact that the government provides healthcare. They can't even conceive of a system where the government doesn't take care of healthcare. Same thing with roads. People or things like money or communications or education. People are so used to these things being provided by the government. I'm sorry, the state, that they couldn't conceive of it happening without it. So if you say I'm against government roads, what they hear is you're against roads because they don't think it's possible to have roads without the state. And the same thing is true of law and order, what I call the institutions of governance or governance itself. So because they think that to have law and order, you need a state, they believe that if you say I'm against the state, you're against governance, right? Because to them, it's a package deal. So sometimes I will try to be carefully clear in my language. It always results in it's a disaster because people confuse. But I'll
yeah,
say
no,
something.
I'm with you. I've given into a colloquial way of speaking where I know that I'm being imprecise with my terms and so on, just because I misuse words like money and things like that, just because
Exactly. You
if you
have
want
no
to
choice.
if you want to
Yeah.
talk in a way that people can understand, you have to be a little bit
Right.
loosey goosey about that.
Yeah. So
So
I usually say I'm against like people libertarians now. They say they're against government schools. Okay, and I could be nitpicky and I could say you're really against state schools, right? Because government is like an ambiguous term. Um, but I know what they mean, so I'm not going to fight them on that, right? They're against the schools that are run by the government. But the way I think of it conceptually is the government has just like roads have been monopolized by the state, the functions of governance have been monopolized by the state.
right.
The state is the fundamental problem. The state is an agency, it's a monopoly force and law in a given area. That's what it is. And because of that monopoly, they outlaw competition in the provision of governmental services. But there's nothing wrong with government per se. You can have
Yeah,
law
what
and order
the
and
family,
courts.
right? Parents govern their children. Companies
Exactly.
have governance that govern them. Your local chess club has governance. I want to return to the Nelson Nash Institute and give you a
Okay.
little bit of. I think now I was with the Nelson Nash Institute, and I want to give a little bit of history. So, not being a member, I might be a little
Let's
bit off. The infinite banking concept was, I would say, discovered by Nelson Nash in the 1980s because the idea predated him. So whole life insurance had existed for over 100 years. And so the methodology he proposed was at least theoretically possible. And I do believe there were people doing it, but no one had really formalized it into a system, written a
Mhm.
book about it. So I'm giving Nelson Nash his due. But when people say that he created it, I'm like, well, I don't know about that. But even if he did, be that as it may, he wrote the book on it. It's called Becoming Your Own Banker. It's a book that is like the seminal work on the infinite banking concept. And then the Nelson Nash Institute was founded later, I don't know, maybe 2010. I'm not sure the exact date. And in order to promote the infinite banking concept. And what happened was over time, I don't know if it morphed or if this was always the original intent, but I believe it started as a way to promote the infinite banking concept and to give support and training and encouragement to life insurance agents who actually want to do the infinite banking concept, which is a very special way of
Mhm.
leveraging
Mhm.
whole life insurance policies,
Mhm.
okay, to become your own banker, right?
Mhm.
And we don't have to get into all of that, but and so they started creating a program where you could pay them some money, get some training, and get like officially authorized as an infinite banking practitioner. And it has morphed into controlling the narrative. It has morphed into like all things, it started off with a real problem. There is a real problem, which is that there are, of course, people who use the infinite banking concept. They use
Mhm.
that phrase, but when they're actually doing is something quite different that
Right.
may not be in the client's best interest. And we don't have to go into all the
Right.
details on that. So they see this real problem, and then they start playing this whack-a-mole game of trying to smack down
Yeah.
those other people, right? Rather than trying to promote and encourage the infinite banking concept. And then whether explicitly or implicitly allying with government in order to do that. And I think also there's sort of a personal, emotional, almost spiritual aspect to it where I don't know how familiar you are with the Nelson Nash Institute, but if you listen to the leadership, you listen to people talk about it, it has become a religious cult,
Mm.
unfortunately,
Mm.
where the infinite banking concept is to them more than just a brilliant financial strategy. It is basically a form of religion.
Mhm.
And so when you criticize Nelson Nash,
Mhm.
or when you misuse the infinite banking concept, or do it in a way that they don't like, it's not just a disagreement. It's now a religious
Yeah.
war. And when you elevate things to that level, then all of a sudden, no holds barred, right? And so because of that, you can see it in the way that these people, some of them, because there are a lot of them that I respect. Let me be clear about that. I'm actually positive on the Nelson Nash Institute, so I hope this is taken as constructive criticism. That some of them get very shrill and very angry. And when you get very shrill and very angry, you are just not going to be effective. It doesn't matter how right your message is. People are just going to see that you're bitter, that you're shrill, that you're angry, and that you're trying to control other people.
Yeah.
And that's not attractive. And so my constructive criticism to the Nelson Nash Institute would be, hey, we agree on the infinite banking concept. We agree that these other people are misusing the infinite banking concept. The question is, what do you do about it? That's the question. And I think it's also partly the psychological phenomenon that we often see, which is that when you get bullied, you oftentimes become a bully, right?
Yeah.
That's the way it works. And we in the infinite banking footprint have absolutely 100% been persecuted and bullied by the Wall Street bullies who don't
Mhm.
like the
Mhm.
financial philosophy, the financial strategy that
Mhm.
Nelson Nash is proposing because it would probably take profits and power away from the Wall Street bullies.
Sure.
And because we get so unjustly beat up by these compliance departments who enforce arbitrary rules that were written by their Wall Street superiors, right? And we've been persecuted. The temptation then is to become like the Wall Street bullies. And unfortunately, I think there's some of that in the Nelson Nash Institute.
Do you think
Uh,
there's a parallel to the Bitcoin thing where, there's been hostility towards Bitcoin among the sort of professional class and the money managers and the old world, the old way of doing things?
I actually don't think so. I think that's a different phenomenon, quite frankly. I think when it comes to Bitcoin, I think a lot of the animosity just comes from envy because they see these little people who supposedly don't know anything who got rich buying Bitcoin and they're
Yeah, but
just
it's
envious.
also, you don't think it's a threat to the old way of investing and say and using banks? Look, you have Craig Wright, who is this notorious sort of Bitcoin troll who's tried to claim he was Satoshi and use trademark and copyright to prevent other people from using the word bit. Even the Ayn Rand, I think Leonard Peikoff, they've sent they filed lawsuits or sent threatening letters telling people you can't use the word objectivism. We own. Like, another example of true. Even the Libertarian Party in recent years has used that against some renegade state Libertarian Party affiliates for using the word Libertarian Party in their name. And again, half the time you have no choice in a sense to police your mark, as I said, but you can see how this, in the case of the Nelson Nash thing you're talking about, okay, if there's a quasi-religious or a fervor about this thing and then there's hostility from the outside, but also worry about renegade groups that are not under their control, you could see how in a free market where there was no trademark rights, the trademark rights exacerbate our tendencies to become bullies. If you didn't have
Right.
trademark rights,
Right.
you would have to rely upon persuasion and persuading people that, oh, I'm the real objectivism. I'm the original, founder. The same thing happened, by the way, with Montessori. My kid went to a
Right,
Montessori.
and they could have their official authorization, that'd be fine, it's just they
Correct.
couldn't use force, they couldn't use force. It would
But
just
if
be a
they
matter of the credibility that it gives,
exactly,
right?
and if they couldn't use trademark to bully people, they would have to be a little bit more careful about selling their claim that they are the legitimate one. Just like there's a debate among Bitcoiners about is it Bitcoin Cash or is it Bitcoin? If you don't have a government lawsuit you can file, you have to give a reason for your claims. I was going to say my son went to Montessori schools here in America, and there was something similar there, but it was a little bit odd because the Montessori approach was come up with by Maria Montessori in Europe 100 years ago, and it was called, and then her group was called AMI, Association Montessori International. But there was a split with the American group for a while because of John Dewey's criticism of it, or some guys' criticism. So Montessori fell out of favor in America for a few decades. And so this woman named Nancy Rambush went to Europe and she found out about it. She started up the American group called AMI. I'm sorry, AMS, American Montessori Society. And that became the dominant way of teaching Montessori in America, the AMS way. And now the AMI way is coming back up. And they both say they're better than the other for different reasons. But there's no trick. They never need to file a trademark. So it's like in the public domain now because it's just a Montessori method, which is very similar to the Nelson Nash thing. It's a descriptive way of talking about infinite banking. It's a description of a system. So no one owns Montessori, the word, the technique. So that means that these groups have to coexist with each other and they have to have friendly competition, and parents can judge them on their merits and decide which one they think is truer to the mission, the original mission, or which one they like better, which is the way it ought to be, right? That's what we should have. We should have no intellectual property rights, amp up the hostility and the legal fighting among each other.
Yep, I completely agree with you. But yeah, I know I've talked about my brief story with it, but hopefully I hope this has helped the audience understand why trademark is a problem, why I agree with the Nelson Nash and try and train and support and encourage agents to do it. I support them in that. Um, and I've invited them to come and talk on my show if they want and have a conversation about this because I think we all want the same thing, which is to promote the infinite banking concept. The
And
question is,
what have they said? What's the response been when you invited them?
there's no response. I'm not in touch with them. I haven't been for some time. So I just stated publicly on my show. We'll see. I mean, it wasn't that long ago, so maybe someone will respond, but I doubt it. Why
If
would
they're
they?
libertarians, if they're libertarians, I think they should, if they want to be serious libertarians and not hypocrites, maybe they should consider what we talked about and consider whether what they're doing is ethical and moral, and reconsider their use of lawfare and state aggression against their, we'll call you competitors, just
I'm not.
against
Yeah, no, I don't consider myself a competitor at all. I think
their
it's
fellow infinite bankers. I
right,
mean, why would
right.
you do that? It's just not right. Reconsider
Yeah.
what you're doing.
So the three people who were leaders at the time I was there when I was kicked out was Bob. And by the way, the reason I was kicked out had absolutely nothing to do with the infinite banking concept. You can look at my videos, I'll link them below and read about my story, but it kind of just shows the pattern of behavior that goes on there. So Bob Murphy, Carlos Lara, and David Stearns were the leadership of the Nelson Nash at the time, the
Okay.
Nelson Nash Institute at the time. So I'm not in contact with any of them personally. I know Bob has left. I'm not sure if Carlos is still there. I know Carlos has had some health issues, so I'm not sure what he's up to. But I think David Stearns is still there, still leading it. So if you're in contact with those people, please give them my invitation because I doubt they've seen the video. It was a public invitation, but I don't have any way of getting in touch with those guys. So I seriously doubt any of them even know that I exist. Probably better if they don't. If they might come after me if they find out I exist. Then I might get a legal letter in my mailbox and I have a lawsuit to deal with. No, maybe staying under the radar from them is a good thing. Not sure.
Yeah, I don't know. I think it's sad. I do have a book I wrote. It's a monograph about 10 years ago. It's called Do Business Without Intellectual Property. Jeff Tucker encouraged me to do that when he was with Liberty.me. And listen, we live in a world of patent, copyright, trademark, trade secret law. You can't deny it. You can't avoid it. You can't ignore it. But if you, but there are traps that people fall into when they just start using these rights without thinking about whether they really need to. For example, if you have a little startup company and you're told you need to devote so much of your precious budget to hiring patent attorneys to get some IP, they call it IP patents, so you can attract VCs and investors, and you have a war chest that will impress Wall Street or your investors because you have a right to sue someone who's a competitor. You hear those on Shark Tank all the time. Do you have any protection on your new product? You can't ignore the reality. Sometimes you need to do this, but you don't always need to do it the way everyone else does it. And maybe you get 1/10 as many patents as someone else, or maybe you adopt a strategy like Tesla or Twitter did, right? And with trademarks, I mentioned other ways you could approach it in an ethical way. And it might even be better because now you're focusing on your core, what you're really about. You're not focusing on lawyers and lawsuits and revenge and beating people with the power of courts. Um, and so in this little book I have called Do Business Without Intellectual Property, it's on my website,
We'll link to that below.
It's on
Yeah, absolutely. No, I think that's great because I think we've had a lot of wide-ranging theoretical discussions with a lot of
Right.
tangents, and people want practical,
Right.
tangible solutions. And I think it was great that you gave one earlier to the Nelson Nash Institute
Yeah.
to say, hey, you can trademark the phrase, but just don't enforce it in the way that you're doing it now.
Correct.
There's a better
Correct.
way that you can do it so that you're not being a bully. You're just
And it's
making
even
it
better.
clear.
It could even be better for them because now they're not seen as a bully and they're not wasting resources chasing things that is not their core business model. Their core business model will be to improve their services and their offerings and their quality and their reputation and just have a prosperous business. Why would you want to why would you want to spend money on guys like me to send out CD letters?
Right. And I want to point out what you said there, focus on improving their services. Because unfortunately, when you look at the way they're going, their focus is on controlling their agents. So it's not about, hey, Stefan, let me train you and teach you how to do case design really well. Let me teach you how to prospect and market and sell yourself so you can really grow your business and you can really design cases well so your clients will have the most efficient cash flow management tool. There's none of that. It's all, Stefan, this is the way you do it. And if you don't do it, we're going to beat you over the head. That's really a lot of what it is. You don't get a lot of support and training like you're supposed to get. The training, quote unquote, is basically more like we're going to fit you into this straitjacket and you're going to comply. We are a compliance department. You're going to comply. And that's it. They seem to have no interest in helping you grow your business or actually become a better infinite banking agent. It's
Right.
more about just controlling, unfortunately.
I don't know if we can do this, but maybe I could quickly share my screen to show this.
Sure. Yeah, you should have. You should be.
It is one practical thing I do. I know I sound totally impractical, but trust me, as a patent attorney, I have had to be very practical with my
Stefan
clients.
will plead guilty to he speaks like an attorney.
I try not to, or I try not to use terms without explaining them anyway and why they're relevant. Okay, how do I share this screen with you?
I can see you. I can see your screen.
Okay, can you see it?
I see Zoom.
I need to move it somehow to unplug my monitor. That's my problem, my monitor. Now can you see it? There we go. So this is Do Business Without Intellectual Property. So if it's practical, it talks about trademark, trade secret, patent, and copyright, things you can do. I'm not saying to shun everything, right? But it's thinking about a different way of 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 navigating this IP prone world. And it's free online. Like everything I do is free online, by the way.
Excellent. Excellent. The man is consistent with his principles. We'll definitely link that below. Stefan, we thank you so much for your time helping us to maybe provide some practical alternative solutions. First of all, point out what's wrong with trademarks and give some practical alternatives to the Nelson Nash Institute for how they might better accomplish their stated goal of promoting the infinite banking concept. Stefan, anything you want to leave our audience with in closing?
No, anyone interested in this, you can. Most of the stuff I've talked about is in my book, which is fairly recent, and that's on my website too. It's free online, EPUB and PDF, and also you can buy Kindle and paper versions.
You must
And
be broke then, Stefan. You must be making no money because you're giving all your stuff away for free. You must be totally broke, right?
it's crazy. People buy it. They're like, "How do I buy your Kindle?" It's like, "Here's a free EPUB." They say, "No, I want the Kindle version." I'm like, "Okay." Uh, I don't do this for money anyway, but it works out anyway. But no, and I might be teaching a course on this later next year. I might do an online course for a reasonable price, just for to go through my entire theory of libertarian concepts, property rights, justice, intellectual property, everything, just in detail for people that are interested in self-education. I did a course like this about 13 years ago for the Mises Academy, but now the technology's better and I have more material to work with. So I may be doing that. I'm retired, so I'm looking for something to do in retirement. So
I got plenty of ideas for you, Stefan. I got plenty of ideas.
all right. I'm open. I'm open. I appreciate your time and good luck with everything, but thanks for having me on.
Thank you, Stefan. Really appreciate it. Bye-bye.
Okay.